The jury questionnaire has come out. We know what's happening when the jury shows up in just a few short days in the people of the state of New York versus Donald Trump in front of Judge Juan Merchan here in New York County, also known as Manhattan, the first criminal trial of a former president of the United States is happening. And what came out is the jury instructions that Judge Juan Merchan is going to give the jury and how jury selection is going to go. So anyone who hasn't served on jury duty, the way it works is you get a summons in the mail, you show up to do your jury service, and you may or may not get called into a courtroom and asked questions. And what the questions are designed to do is see if you could be a fair and impartial juror in this particular case. You might be a fair person, but for whatever reason, this particular type of case is not suited for you. And that's the purpose of what's called voir dire, or the jury selection process. So what this is happening here in this particular case is a few things that are unique to this case, given the amount of publicity surrounding it, given who the parties are, and given the level of interest in this case. So also really quick, there's just two things I want to explain before we go into the nuts and bolts in New York with voir dire and the jury selection process. So unlike federal courts, the parties are actually allowed to question the jurors themselves. In federal court, only the judge conducts the voir dire and asks the questions. But in New York State court, you get to ask questions as well. And the way it works is the people, who's the government or the prosecutors, are called the people. So the people go first, and then the defense goes second. The judge will give them each a certain amount of time. It's really particular to the judge. There's some judges who only give you a little time. There's some judges who give a lot of time. But before the parties go, the judge asks some general questions. And so the judge gives some instructions to the jury and asks questions. He calls a certain number of them into what they call the box, which is it's again, it just depends on the judge, the courtroom, and the size. But sometimes it's maybe 40 people will go into the box, and the judge will give instructions, will ask questions, and then turn it over to the parties to ask their questions. And the questions can only be designed to determine who could be fair and impartial in that case. And then afterward, they go through the challenges. And there's two types of challenges. There's the for cause challenge, and then there's the peremptory challenge. The for cause challenge means that a person is ineligible to serve based on, it's either the judiciary law qualification, so you don't read or write or speak English, for example, you can't serve, or you don't live in the borough of Manhattan, you can't serve, things like that. And then there's the, are you fair and impartial? And you could say, I could never ever look at the evidence fairly. I think Donald Trump is innocent, and this is a witch hunt, and I couldn't, no matter what you showed me, I couldn't be fair and impartial in this case. Well, that juror would be challenged for cause. And there's an unlimited number of for cause challenges, because anyone who's not qualified to serve as a on jury duty for a particular case will get excused, no questions asked. And then there's what's known as peremptory challenges. And the number of peremptory challenges each side gets depends on the level of crime that you're charged with. It's defined in a statute. And in this particular case, each party gets 10 peremptory challenges each, because it's a Class E felony, which is the lowest level felony. And those are your no matter what challenges. You can just challenge them because you like other jurors better, or you think that young women might feel something in some direction for something. I mean, you have to have some articulable reason. It can't be because of race. It can't be because of anything like that. You can't just say, oh, I don't like all white people, or I don't, whatever it is, that you can't, that shows bias. But you have to have a reason that you articulate about that particular person, but it can be any reason whatsoever. Oh, that person's reading a book. I saw they walked in carrying a book, and it's a book on Donald Trump, and I just don't want someone who's that interested that they're reading this book, and so therefore I don't want this person. So things like that. Those are peremptory challenges, and then you basically get a jury, and they're going to try to get 12 jurors, and I'm sure 6 or so alternates, because that's how typically you would do a case like this. And then opening statements will start. So let's talk about the specifics of jury selection in this case. So there's a letter that the Judge Juan Merchan, sent to counsel, to Todd Blanche, who's representing Donald Trump, and ADA, which stands for Assistant DA, Josh Steinglass, who's one of the lead lawyers on this case, someone I've worked with for a long time. He's a fantastic trial lawyer, and is also the prosecutor who prosecuted the Trump Organization case successfully and got a conviction for tax fraud back in November of 2022. So it says, "Dear counsel, I write to you regarding jury selection. This letter will address 3 separate issues. Number 1, excusing the jurors who self-identify as unable to serve. Number 2, instructions regarding the use of an anonymous jury. And number 3, the jury questionnaire and the permissible scope of voir dire." So excusing jurors who self-identify as unable to serve. The court typically conducts jury selection in the following manner. I read the caption and introduce the defendant and counsel, and I identify what the charge is against the defendant and briefly outline the nature of the case, providing a brief summary of the allegations. The brief summary of the allegations that he's going to read, by the way, he put in here, and I think they are excellent. So I am going to read those to you. And the brief summary of the allegations is as follows, and this is what he's going to read to the prospective jurors. The defendant, Donald Trump, is charged with 34 counts of falsifying business records in the first degree. The allegations are, in substance, that Donald Trump falsified business records to conceal an agreement with others to unlawfully influence the 2016 presidential election. Specifically, it is alleged that Donald Trump made or caused false business records to hide the true nature of payments made to Michael Cohen by characterizing them as payment for legal services rendered pursuant to a retainer agreement. The people allege that, in fact, the payments were intended to reimburse Michael Cohen for money he paid to Stephanie Clifford, also known as Stormy Daniels, in the weeks before the presidential election to prevent her from publicly revealing details about past sexual encounter with Donald Trump. Donald Trump has pleaded not guilty and denies these allegations. I think that's significant because the judge is underscoring the people's theory, which is that this is an election interference case, and this was about trying to interfere with the 2016 election, and therefore any evidence that tends to support that will be admissible. This isn't just about hush money payments. This isn't just about falsifying business records. This is about trying to influence the 2016 election. So I think that's significant. So he also goes on to say, I will also explain what an indictment is, what my procedure for jury selection is, the role of the jury in the court, and the definition of a fair juror, the various stages of the trial, some basic principles of law that govern, including the presumption of innocence, a defendant's absolute right not to testify, and that no negative inference may be drawn against a defendant who chooses not to testify, how law enforcement testimony is to be evaluated, and the nature of jury deliberations. I also provide the prospective jurors an estimate of the length of trial and the anticipated schedule. In this case, I will also inform them that the court will not convene on any days or times that might conflict with their observance of Passover. I'll explain that the observance of Passover does not preclude them from serving, et cetera, et cetera. So he goes on and says, I then read the names of potential witnesses as well as the names of people who may be mentioned during the trial. And that's important because what will happen right before they get started is each party will give a list to the judge of their potential witnesses or names that might be read at trial. So it's broader than a witness list. It's names that might come up at trial, et cetera, may or may not testify, and ask if anybody knows anybody. And then he'll say at the end, the judge, now that you've heard my preliminary instructions and some basic information about this case, if you have an honest, legitimate, and good faith reason to believe that you cannot serve on this case or that you cannot be fair and impartial based solely on what you've heard up to this point, please let me know. Please do not wait until after you've been selected to tell me that you can't be fair and impartial. The law gives me much greater discretion to excuse a juror when you're a prospective juror than to excuse a sworn juror from a sworn jury panel. Having said that, please be advised that simply having work, school, or childcare responsibilities without more is not enough to get you off jury duty, etc. So then he invites the jurors who have self-identified and wish to be excused to line up at the rail and approach the bench individually and explain why they should be excused. But you'll be joined at the bench by defense counsel, the prosecution, the court reporter, and at least one of the court clerks or court officers, and by the defendant if they have not waived antimarchy. So what that means is there's a case called antimarchy. It gives the defendant a right to be present at all parts of jury selection, including bench conferences. And there was a case, antimarchy, where that wasn't done, and the case was reversed just based on that error alone. So now in every single case, they make sure that the defendant is either up at the bench and listening to what the juror has to say, or waives that right. They have to be told about it and waive that right. It can be very unsettling, by the way, for an individual juror to be that close to somebody accused of a crime. So they try to get people to waive the antimarchy rights, but they don't have to. But what the judge has said is essentially, because this particular case has unique features to it, including the fact that there's the defendant, there's Secret Service, there's multiple attorneys, etc. It would be very difficult and unrealistic to do that process that I just described up at the bench and interview each juror. There's no room big enough to do this, and the time that it would take would be time-consuming and unproductive. So what he said is, instead, what I'm going to do is I'm going to accelerate the process significantly. And if somebody says, if they self-identify that they cannot serve on this case and that they feel that it's fair and they can't be fair and impartial, they're just going to take them at their word and not go through that lengthy process, because this is such an important right that I just said that a defendant has the right to do, that in order to keep this moving along, if somebody doesn't want to serve and they identify as not being fair and impartial, I'm just going to disqualify and then let them go. So that's how he's doing that. Then he goes on to the instructions on the use of an anonymous jury, because he did order, right, if you recall, in March 7th, 2024, that the people's motion for a protective order regulating disclosure of juror information was granted. And he said essentially that the address of any sworn juror is only going to be permitted to go to the party's counsel. I'm sorry, the counsel for the parties, not the parties themselves, not Donald Trump himself. So the address, he does not get the addresses, but his lawyers do. And the names will stay totally anonymous to the outside world, and except that it is allowed to Trump and counsel and the people, but again, not to the outside world. So it is an anonymous jury. And he did order that the parties submit a joint proposal for a neutral explanation as to why it is that their names are going to be kept secret or anonymous. And they were unable to come to an agreement. And so the court received separate limiting instructions. And what he said was he came up with the actual instruction that he's going to give, which is the court and both parties in this matter have agreed that your names will not be publicly disclosed. Further, your addresses will not be shared with anyone other than counsel for the parties. We're doing this to preserve your privacy and to protect your identities from members of the public. You must not draw any inference in favor of or against either party as a result of this order. So again, the judge has to be careful not to prejudice Trump in any way by letting jurors think, oh my God, this guy's so dangerous, or his people are so dangerous, I'm scared to serve on this case. That will distract from the evidence if you're worried about your own safety. So the judge has to be careful about that. And then finally, he gets to the part about the jury questionnaire and how he's going to handle the jury questionnaire. And he has, what he's decided to give is a let's see, 42 questionnaire that he's going to have people fill out. And I'm going to just read to you some of it. So it says here at the top of the questionnaire, each juror who's seated in the jury box will be asked to answer the following 42 questions, beginning with the juror in seat number 1. Please do not read the questions aloud. That is not necessary. Simply state the number of the question and answer each question one after the other in a loud, clear voice. Depending on your answer, we may ask you follow-up questions. When you're finished answering all the questions, we'll move on to the next seated juror until every juror has had the opportunity to answer. So the jury's sitting in the box, right? They're sitting there with numbers because we don't get to know their names. And they have this piece of paper in front of them with these questions, and they're just going to read their answers. They're not going to read the question first. They're just going to read their answers and go down the list. And the parties are going to be taking notes on their little jury note-taking pad and see, okay, I want to pay attention to what they're saying, because if they say something that's a for-cause challenge, I'm going to make sure I write that down and write it down verbatim, because I don't want to waste one of my 10 peremptory challenges if I want them off the case, because there's unlimited for-cause challenges. So you write, and then if there's a juror you like and they say something, you write that down. If they say something that could hurt, that the other side isn't going to like, and that they're going to want to do a for-cause challenge, and you go, and when it's your turn to go, you try to rehabilitate them by asking them rehabilitative questions. So there's this whole art to note-taking and what you pay attention to and what you write down, because everybody's trying to get the jurors that they want on the case, but ultimately the person who's going to be fair and impartial. So the questions are things like, without telling us your address, what neighborhood do you live in, how long have you lived there, what do you do for a living, how long have you been doing that, if you're retired, what did you do before you were retired, who's your current employer, who is your prior employer, what's your educational background, are you married, have you ever been married, do you have children, what do you like to do in your spare time, do you have any interests or hobbies, do you participate in any organizations or advocacy groups, have you ever served on a jury before, if so, tell us how long ago. Was it criminal, civil, or the grand jury? And without telling us the verdict, did you reach a verdict? Why do people ask that question? Is because lawyers like to know that it's hard to sit in judgment of somebody. So it's good to know that you were able to at least reach a verdict, as opposed to I can't decide, right? So that's why that question. And then, which of the following print publications, cable or news network or online media websites or blogs do you visit, read, or watch? Because I guess they're trying to see, are you a Fox News person or a MeidasTouch person? But it's New York Times, USA Today, New York Daily News, Huffington Post, CNN, et cetera, et cetera, et cetera. Then it says, do you listen or watch podcasts? If so, which ones? Do you listen to talk radio? If so, which programs? Have you, a relative or a close friend, ever been the victim of a crime? If so, tell us what happened. Have you, a relative or close friend, ever been employed by law enforcement? Because you want to get law enforcement bias out, right? Have you ever been employed by a federal, state, or local government agency, or accounting, or finance? Do you have any particular experience in criminal law or in the legal field? Do you have any experience with the criminal justice system? Or have you, a close friend or relative, been accused of a crime or convicted of a crime? Or do you have any pending criminal cases? Do you have any political, moral, intellectual, or religious beliefs or opinions which might prevent you from following the court's instructions? There are some religions that you can't sit in judgment of somebody. Do you have any political, moral, intellectual, or religious beliefs or opinions that would interfere with your ability to render a verdict in this criminal case? Do you have a health condition that would interfere? Don't tell us the name of any medication you take, but do you have any that would prevent you from being able to concentrate or pay attention during deliberations or the trial? Court proceedings normally end at 4:30 in the afternoon. On rare occasions, we might work beyond that. Would your schedule permit that if that was required? Do you practice a religion that would prevent you from sitting on any particular weekday or weeknight? Can you give us an assurance that you'll be fair and impartial and not base your decision on this case on bias or prejudice in favor of or against a person who may appear in this trial? So again, that's the bias or prejudice. That go on about stereotypes. Do you have a friend or relative who's ever worked for Donald Trump or anyone in his family? Had anyone ever volunteer for a Trump campaign or the Trump administration? Have you ever attended a Trump rally? Are you signed up for, or have you ever been signed up for, subscribed to, or followed any Trump newsletter. So it's all about his social media, his et cetera, et cetera, et cetera. It goes A through H with all of the various questions under question 29 about Trump. Then it says, have you ever considered yourself a supporter or belong to the QAnon movement, the Proud Boys, the Oath Keepers, the Three Percenters, the Boogaloo Boys, and Antifa? Wow. Do you have any strong opinions or firmly held beliefs about whether former president may be criminally charged in state court? Do you have any feelings about or opinions about how Mr. Trump is being treated in this case? Can you give us your assurance that you'll decide this case solely on the evidence as you see and hear in this courtroom? Do you have any strong opinions about the former president, Donald Trump, or that he's currently a candidate? Have you read or listened to the following podcasts? Disloyal. These are podcasts by Michael Cohen or Mark Pomerantz. Mark Pomerantz is the former special prosecutor who left the DA's office when the case he was investigating didn't get prosecuted, the one that's the civil fraud case in front of Tish James. So there's 4 podcasts they mentioned: Disloyal, which is a memoir; Revenge; Mea Culpa, a podcast; or The People versus Donald Trump. Interesting that they don't mention Legal AF or Political Beatdown or the MeidasTouch Network, but that's fine. I like staying below the radar. The defendant has written a number of books. Have you listened or read any of them? If so, which ones? Do you have any opinions about the legal limits governing political contributions? Can you promise to set aside anything you may have heard or read about this case and render your verdict based solely on the evidence presented in this courtroom? Can you give us your absolute assurance that you'll refrain from discussing this case or watching, reading, or listening to any accounts of the case during the trial? Can you assure us that you will follow the judge's instructions and follow the law? The United States Constitution provides that a defendant has no burden to introduce any evidence or to testify in a criminal case. If Mr. Trump chooses not to testify or to introduce any evidence, can you give us your assurance that you will not hold that against him? And final question, is there any reason, whether it be bias or something else, that would prevent you from being a fair and impartial juror if selected in this case? So those are the questions essentially that will be asked. In addition to the answers, the lawyers will be looking at the body language. When someone asks, do you watch Fox News? Do you answer no, or do you answer, no way, never? Obviously that tells you a lot about the person, things like that. So there's a jury selection. Don't let anyone tell you otherwise. It's the single most important part of any criminal case. It's all about the jury. The jury decides the case. The jury is the one who reaches the verdict. The jury is who you're presenting the evidence to. It's who you're talking to. It's who is going to sit in judgment. And so it's very, very important. Now we have a window into exactly what the judge is doing. And that's your voir dire Legal AF Law School installment of the day. I am Karen Friedman-Agnifilo with Legal AF. Join me and my co-hosts every Wednesday and Saturday, and join me every day starting with this podcast, or this little podlet that I just did on the jury selection in this case. I'm going to do every day, at least one a day, on Legal AF Law School, The People versus Donald Trump Manhattan DA case. So stay informed. We're all here. We're going to watch it with you. We're going to tell you about it. It is not going to be, it's not going to be audio broadcast. So we'll just tell you what we glean and what we learn and what we read and what we see. So join me, and thanks for joining this journey with us.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.